hearing in the appeal, O'Connor and Barnes Standards Board.
Yes, Mr. Anderson. My Lords, I appear with Mr. Chelvan for the appellant, and Miss Alison Padfield appears for the respondent.
Who's been in the case throughout, as I understand it.
She has that advantage,
Yes.
my lady, yes. Mr. Chelvan and I are new to the case. We're hoping that that doesn't show too much. The first question is whether a BSB prosecution is a series of discrete acts or a continuous act for the purposes of Section 75A.
Mr. Anderson, I should perhaps say we've discussed how we think this hearing should proceed, and we suggest that you present your appeal on the limitation point, and then Ms. Padfield responds to your appeal on the limitation point, and then tries to persuade us to listen to her quasi-cross appeal on the discrimination point.
Yes.
And if we decide that we will allow her to address us on that, well, then you can respond
Yes.
in the usual way. That makes sense, doesn't it?
My lady, yes. There is one potential problem with that, which is that in the respondent's printed case, the issue of the merits seems to feature quite prominently in the limitation arguments. I think what the respondent is saying is that you've only got the original decision is your only possible case, and any case based on a failure to act is hopeless, and therefore there's no actual limitation argument about a case based on failure to act. It's more a merits argument, so I may have to stray into
You may indeed. That's understood.
Yes.
But in terms of seeking to persuade us not to interfere with the first instance decision on whether you had an arguable case, that can come later.
Yes, thank you. As I say, the first question on this part of the appeal is whether a prosecution is a discrete act or a series of acts. And we submit that the Master of the Rolls provided a succinct, clear and correct answer to that in paragraph 21 of his judgment, which is at memory stick page 174. As he said, in the present case, the complaint is that the prosecution...
Sorry, which paragraph, please? Which paragraph?
21.
Thank you.
In the present case, the complaint is that the prosecution was in breach of Article 14. I can see force in the argument that normally the institution and conduct of a prosecution up to conviction or acquittal should be regarded as a single continuing act for the purposes of Section 75A. The prosecution is a single process during which the prosecutor takes many steps. It cannot have been intended by Parliament that each such step would be an act to which the 1-year limitation period would apply. If that is right, the 1-year period starts to run from the date of the conclusion of the prosecution by conviction or acquittal. He then spoils it a bit by saying, but it's not necessary to express a concluded view about this in the present case. And of course, we invite this court to do so and to express it in those or very similar terms. Milady, the claimant, Mrs. O'Connor, acquired victim status on the 23rd of July 2010, when the charges were preferred against her. And what she complains about is a continuous positive act of prosecuting her, giving rise to a continuous state of affairs of being prosecuted. She was a victim because of that state of affairs. If we look at Section 75A itself, which is behind the first tab in the Authorities Volume 1, yes, page 561.
Sorry, you'll have to speak up a bit, you know. The acoustics in this room are not of the best.
I'm so sorry.
I feel fairly sure that the people at the back of the court can't hear a word you're saying.
Section 75A, proceedings under subsection 1A must be brought before the end of the period of 1 year beginning with the date on which the act complained of took place. We say that the act was still taking place on the 21st of February 2012, which is, of course, the date 1 year before the issue of proceedings, and so that these proceedings were brought within 1 year of the act taking place. It was still taking place a year before, and therefore the proceedings are in time. Of course, it's true that a prosecution, as well as being a state of affairs, involves a series of steps. And we perhaps somewhat sedulously set out some of those steps in paragraph 4 of our printed case. But where a barrister complains that she was prosecuted for reasons which infringe her convention rights, she isn't complaining about each of those steps individually. She's complaining, in the words of Article 14, that her rights and freedoms are being interfered with, and on discriminatory grounds. A state of affairs which in this case lasted until the prosecution came to an end. The Master of the Rolls was right, we say, that the Parliament cannot have intended that one reads Section 75A in terms of a series of causes of action for a series of acts, each with its own limitation period. If that were the position, then presumably each act would have its own cause of action, and presumably each cause of action would attract its own award of damages. So you'd have to assess damages for, in a civil case, for example, if it was brought against you by the state for inadmissible reasons, you might have to assess damages for having to file an acknowledgement of service, for having to serve a list of documents, and so on. That doesn't make sense. We say that it only makes sense to concentrate on the process as a whole. Now, the respondent doesn't accept that this process is what the claimant is complaining about. Focusing on the words "the act complained of," the respondent seeks to characterize that act as a one-off decision to prosecute, followed by a failure to act, that is to say, to offer no evidence. This is perhaps most explicit in paragraph 16 of Miss Padfield's printed case. One problem with that, my lady, is that that isn't how the claim is in fact pleaded. If we look at paragraph 23 of the particulars of claim, which is electronic page 300, I think. I have to do a bit of mental arithmetic every time I cite an electronic page. I don't have them on my printed copy, but
that'll keep you on your toes. Because Lord Kerr and I demand the electronic page references.
Well, that mental arithmetic of adding 164 to a number is the least thing that'll keep me on my toes this morning, I think. But the paragraph 22.
Yes.
The defendant infringed the claimant's right to a fair trial on grounds of her race in breach of Article 14. The refusal to allow sufficient time to prepare, that sentence isn't relevant anymore. Reading on, black and ethnic barristers are more likely to have a complaint referred for disciplinary action, are more likely to be convicted, and are more likely to have those convictions upheld. The claimant avers that the fact that every element of the defendant's disciplinary system impacts on black and ethnic barristers more adversely indicates that there is a systemic bias against black and ethnic barristers. There is no objective or reasonable reason why, given that black and ethnic barristers make up such a small proportion of the bar, they are more likely to be investigated following a complaint, more likely to have a complaint referred for prosecution, more likely to be prosecuted, more likely to be convicted, and more likely to have those convictions upheld. There is no objective reason why the defendant ignored its own rules and prosecuted the claim. Now, much of that is no longer alive in terms of allegations, because Mr. Justice Warby said that the only part of those paragraphs could go forward. But the fact is that they make clear that what the claimant is complaining about is the system, and not just the decision to refer her to a disciplinary tribunal. She goes too far in some respects, because she speaks about the outcomes of the disciplinary proceedings, which of course are not a matter for the BSB. But it does make clear that the complaint is about the whole system, the whole shooting match from start to finish.
So what's the nexus between the complaint about the system and the complaint about the way in which she was treated? How do the two mesh?
Well, we don't know at the moment. What we know is that there is a disproportion. There is a lot that was strange about this prosecution, and it isn't for the claimant to say exactly how the discrimination that she alleges operated. It's for the defendant to show that it did not operate.
Well, surely the answer to my Lord's question is that they mesh because there was no basis on which the prosecution of the appellant should have taken place, and therefore one looks for a reason to discover why it should have occurred.
My Lord, yes. So the problem with the argument that I'm meeting, which is that I'm really only complaining about a decision to prosecute, the answer is, well, I'm not complaining about the whole process. Of course, the questions that I've just been answering will arise when it comes to assessing the merits of the claim. It may be that the claimant won't be able to make it out, and it may be that the defendant's objections that there's no evidence to support the claim that could, in theory, be right. But this is the problem with a summary judgment application, which is what this is. The facts haven't been found yet. And so we have a respondent who's saying, well, this is your allegation, or this is the only allegation you can ever make out. And the Supreme Court's being asked to perform the mental gymnastics in imagining what might be found, and then deciding when that occurred, was it a continuing act, and so on. And it's all terribly unsatisfactory. But in the end, as I said at the outset, the answer that is given to this claim ultimately isn't a limitation answer at all. What's being said is that the only claim, the claim that you've pleaded is hopeless. You can only sustain a claim for the decision, and that, of course, is out of time if I'm confined to the decision. We identified in our printed case 3 questions which we distilled from the Statement of Facts and Issues. This is at page 126. The first issue is the one that I've just been addressing. I'll come to the second issue in a moment. I'm not sure at the moment whether the third issue is a live one or not for this court. I'll explain why. If the prosecution, if I'm right that the prosecution is a continuing act or even a failure to act, and the appeal to the visitors was a part of it, then in my submission, the respondents haven't actually advanced a limitation argument at all. But as I say, it has been driven to saying that there is no viable case. I won't go over lovingly the respondent's printed case now, but that's particularly so in paragraphs 7 to 24, especially at 9, 16 and 24. So I don't think Ms. Padfield is making an argument that even if we are right that the appeal was part of the same process and that it's a continuing process, that nevertheless the time begins to run from the beginning of that process.
Well, we'll wait and see what case she makes.
Yes. But
In the meantime, the two really crunch questions are the discrete act or continuous act question, which you've just been talking about, and possibly of even greater interest, whether
the
prosecution ends with the tribunal's verdict.
The reason I raised it at this stage, though, is that I've come to Scottish ministers, and it's a case that occupied some attention in the Court of Appeal, and which I submit ultimately doesn't get us anywhere in this court. But because the Court of Appeal gave it so much attention, I feel that we should deal with it. It's in the Authorities, Volume 1, at tab 10, page 904. And as your lordships will recall, the pursuers complained of a series of segregation orders, giving rise to a continuous period of segregation, which in the case of two pursuers began more than 1 year before they began their proceedings, but ended within that year. So that is analogous to the position that would obtain if the prosecution and the appeal are one and they are a continuing act, because the proceedings in this case were issued within a year of the ending of the appeal.
I mean, the actual facts are not terribly clearly identified by their lordships, perhaps because they weren't clearly identified to them.
Well,
but it does rather appear that the governor of the prison, in order to authorize the segregation of a prisoner, had to make a decision about that every single month. And if so, then you really have got a situation of a series of acts.
Yes.
And if so, it's a very different situation from yours.
Absolutely, yes. Lord Mance gives the best help on the facts, I think, at paragraph 196, page 963.
Sorry, paragraph?
196.
Thank you.
Second sentence, beginning Henderson. Henderson commenced proceedings more than 1 year after the end of 4 of the periods of segregation of which he complains. So it would appear that he was in difficulty. Blanco commenced proceedings on the 6th of November 2003 in respect of his segregation under a series of orders made over time between the 1st of August 2002 and the 7th of January 2003. Each order made in the cases of Henderson and Blanco was initially made by the prison governor for a maximum of 72 hours, but was within that period authorised and so extended by the Scottish ministers for 1 month from the expiry of the 72-hour period. It was under the rules open to the prison governor at any time to cancel such an order or to vary it to restrict its effect. Potentially, therefore, Henderson and Blanco have complaints about the making and or authorisation of each order and or about the prison governor's failure to cancel or vary it during its operation. So my Lord Wilson is quite right. There were a series of segregation orders made over a period of time, but the Scottish ministers then affirmed the orders and therefore extended them, but then the prison governor could have cancelled the order at any time, and therefore there was so the claimants said, the pursuers said, a continuing failure to act. And but the issue that we're concerned with is formulated at paragraph 3 of the judgments, which is page 908. It was third of 5 issues. where a continuing breach of convention rights over a period of time is alleged, time begins to run for the purposes of Section 7.5 from the first date on which the breach occurs. So somebody was arguing, the defendants were arguing that it was that they were all out of time because the period begins on the first day, which here would be the equivalent, I suppose, of the decision to prosecute. And Lord Hope, paragraph 51, page 923, remained faithful to that issue as so formulated. He said, from letter G, 2 lines down.
I'm sorry, could you give me the paragraph number again and the page number?
923.
Thank you very much.
Paragraph 51. Having held that actually Section 7.5 doesn't apply at all, so it's worth bearing in mind that this was all obiter in every case. Having held that, if it's necessary to express an opinion, however, 5th line, I would hold that the phrase "the date on which the act complained of took place" in Section 7.5a means in the case of what may properly be regarded as a continuing act of alleged incompatibility, that time runs from the date when the continuing act ceased, not when it began. Otherwise, it would not be open to a person who was subjected to a continuing act or failure to act, which was made unlawful by Section 6.1, to take proceedings to bring it to an end without reliance on Section 7.5b, while it was still continuing after the expiry of 1 year after its commencement. I would also hold that so long as the proceedings are brought within the time permitted by Section 7.5a and any longer period allowed under 7.5b, damages may be awarded as just satisfaction for the whole of the period over which the continuing act extends, including any part of it that commenced before the period of 1 year prior to the date when the proceedings are brought. The position would be different for the reasons given by Lord Mance if the orders and authorisations complained of were to be seen as a series of acts with continuing consequences. So the issue as formulated hadn't actually raised the question, which is the first question before this court today: is it a continuing act or a series of acts? The question, as I pointed out, as actually raised in this case, was merely does limitation start at the beginning or the end? And Lord Hope stayed faithful to that. He didn't speculate on the nature of the act complained of, but just said it's not the beginning, it's the end. And that was the choice he was given, and that was the answer he gave. And that explains his sentence at letter H. Otherwise, it would not be open to a person who is subjected to a continuing act or failure to act to bring it to an end, because after a year, if he'd still segregated after a year, he'd be statute barred without Section 7.5b. Lord Walker agreed with Lord Hope on these issues, but Lord Mance page 964, we were just looking at this. This time, paragraph 197, though, I referred to him for the question, for the facts, but at paragraph 197, he gives his opinion, and he didn't, because of the view he took, he couldn't stay faithful to the issue as formulated by the parties. He says that assuming that Section 7.5 of the Human Rights Act applies, the language of Section 7.5 appears to me clear-cut. The starting point is to identify the date on which the act complained of took place. Each monthly order and authorization constitutes for that purpose a separate act. Subject to any shorter time limit, a segregated prisoner who complains of segregation pursuant to any such order or authorization must do so within 1 year of the relevant order or authorization under Section 7.5a, or ask the court to grant an equitable extension under 7.5b. Similarly, so far as the complaint is that during any monthly period the prison governor failed to exercise his power under Rule 87 to cancel or vary, that complaint can, under Section 7.5a, only relate to any such failure occurring within the year prior to the bringing of proceedings, or otherwise the court's discretion must be invoked under Section 7.5b.
Doesn't it depend on what you're complaining about?
Yes.
Because a segregated prisoner may be complaining about the very fact that he was segregated, or, as indeed happened in the big case about segregation that we had from Scotland, about the cumulative effect of many segregations amounting, because of their duration and the circumstances of segregation, amounting to cruel and inhuman punishment or treatment, Article 3 breach. Now that's complaining about the whole period.
Well, Lady, yes, it depends. Ultimately, of course, it doesn't depend on what anyone's complaining about. It depends on what facts have been found and how the conduct has been characterised by the trial judge, an advantage which we don't have in this case. So that's the first point. So, but
all I was trying to say something helpful to you. I don't know if you understood that. I was trying to say that if a prisoner was complaining that he'd been segregated for 5 years, shall we say, as I think was the case in one of these, it doesn't make any sense to say that he should have been complaining about each monthly period of segregation, because that's not what his complaint is.
No.
His complaint is the cumulative effect of all that segregation.
Right, so, yes. But the wider point perhaps is that it isn't really helpful to look at one case about segregation in Scottish prisons under a statutory instrument particular to that jurisdiction to decide whether a prosecution is an act or a series of acts or what. One has to look at the particular facts of the particular case with which one is dealing. But for what it's worth, Lord Mance characterised the segregations in this case as a series of acts, of orders, but he also, and contrary to what we said in our printed case, for which we apologise, he does provide some help with failure to act as well. He's saying that there is a continuing failure to act here, which runs all the time, because the governors could have cancelled the segregation at any moment. And his answer on the limitation issue with the failure to act was that that complaint can only be brought under 7.5a if part of the period of segregation was within the year before the proceedings were issued. Lord Scott gives a similar answer to Lord Mance. This is paragraph 81. Page 933. Reading from letter D, if the orders directing or extending segregation were unlawful as being in contravention of Blanco's convention rights, it would seem to follow that for so long as the segregation continued, there was a day-by-day breach of Blanco's convention rights brought about by the governor's failure to exercise his power to cancel the segregation. Time under section 7.5 begins to run from the date on which the act complained of took place, 7.5a. But act includes a failure to act. So it follows, in my opinion, that the 1 year beginning with the date on which the act complained of took place should simply be calculated back from the date on which section 7.1a proceedings were commenced. So he again was unable to answer the question directly that had been put by the parties, but spoke in terms of a continuing act, and saying that part of it had to be have occurred within the year before the proceeding.
Day-by-day breach. I mean, why not, I don't know, hour-by-hour breach? Why not second-by-second breach, Mr.
Yes.
Anderson?
Well,
if that's the right analysis.
in the present case, one wouldn't think of a prosecution as an hour-by-hour breach or a day-by-day breach or a month-by-month breach. It's a breach that lasted between the 23rd of July 2010 and the 17th of August 2012. And it was one state of affairs that persisted for that period. It was, in one sense, second by second, but no one would talk in those terms.
No.
Now, of course, we mustn't overlook that the Court of Appeal expressed a view on this in the present case, in paragraph 21 that I've already read out, as it applies to this case. And I submit that that view is correct. On any of these analyses, whether Lord Mance and Scott on the one hand or Lord Hope and Lord Walker on the other, by the way, I should say Lord Rogers said nothing about this at all, except I think he said that Lord Mance's position was at least arguable. But he actually, the last line of the relevant paragraph in his speech said, "I'm not going to express a view." But on any view, if the
Well,
prosecution...
it's all obiter, isn't it? Because
It's all obiter, yes.
they decided that Section 7...
Didn't apply.
It wasn't a Section 7 action, and so Section 7.5 didn't apply.
That's right, yes, yes. But as I say, on any of their lordships' analysis, if the prosecution is a continuous act, or for that matter a failure to act, and if it includes the appeal, then this claim can't be statute barred, because at least part of it, even on Lord Scott and Mance's analysis, if there is an analogy at all, at least part of the prosecution on that scenario occurred within the relevant period. Now, that may give rise one day to the question of whether Mrs. O'Connor can recover compensation in respect of that part of the prosecution which occurred before the 1 year before the issue of proceedings or not. If she can bring the proceedings if the other two questions are answered in her favour, but a question will arise as to whether she can recover compensation because of the whole prosecution or for only that part of the prosecution that took place after the 1 year before she issued proceedings.
But she doesn't have a right to compensation in any event.
No, she doesn't, but she has a right to claim compensation.
That's right to ask for it, yes.
Yes. And she, but whether she will get it is ultimately a matter for the trial judge. I don't know if this court is interested in hearing arguments on that issue. I discussed this with Ms. Padfield yesterday, and it's fair to say that we haven't come to a consensus on it.
It doesn't seem to me, speaking for myself, to be within the scope of your appeal.
No. We're certainly content for the action to go forward and for that matter to be dealt with.
Not least because the whole principle of compensation under the Human Rights Act is completely different from the principle of compensation
Yes.
Under the law of tort.
Yes.
It's not for us at this stage to try and go into what the principle might be in a situation such as this.
Yes, that's
raises all sorts of different...
I think that's what well, certainly, I don't seek to dissuade the court from that view. So I'll move on in that case.
It looks as if my lady and my lords are content with the view I've just expressed.
Yes. Thank you. So I can move on to the question of whether the prosecution ends with the verdict of the tribunal or only with the verdict of the visitors. But, by the way, my submission about Scottish ministers is that ultimately it takes us nowhere. Does the prosecution end with the verdict of the tribunal or with the visitors? We appeal to natural use of language. If one looks at Mr. Justice Warby's judgment, paragraph 2, page 182, thank you. He states in a nutshell, the appellant is a practising barrister. She has sued the Bar Standards Board for damages in respect of disciplinary proceedings against her, which ended in her acquittal on appeal in August 2012. So the disciplinary proceedings ended on a natural use of language with her acquittal on appeal. The conviction by the tribunal was not an end of the matter. The disadvantages that accompany a prosecution continue until it's finally resolved. Only when the charges are determined will the infringement of which Mrs. O'Connor complains come to an end. It would be counterintuitive, to say the least, that a continuing breach of convention rights can end with a wrong outcome, with a conviction that shouldn't have occurred, before a domestic appeal has been exhausted or has run its course to put right that wrong outcome. And it would be even more counterintuitive to conclude that the infringement of Mrs. O'Connor's rights had ended when actually the party who had secured the conviction was still actively participating in the proceedings to resist its reversal on appeal. So if one in paragraph 19 of the Respondent's printed case, this is page 145, it's said that the appellant's case runs into difficulties on the facts because, I'm reading from the last 4 lines, the appellant was convicted even though her appeal ultimately succeeded, and because at an earlier stage the appellant applied to strike out the charges against her, and Mr. Justice Field, sitting as a directions judge, decided that the case should go forward to a substantive hearing. We had to put in a supplemental bundle, which isn't, for which apologies. I hope your ladyships and lordships have it.
Have you put it in electronic form as well as hard copy? I've certainly got the hard copy.
Not in editable electronic form, for which we apologise. It was sent in by email as a PDF, but I know what your ladyship means, and we apologise for that. There is a paper version.
Yes, we've got the paper version.
The judgment of Mr. Justice Field would probably be in the page bar at the top of Adobe, if that's what your ladyship's using. Page 5, I think.
It's going to be quite difficult for Ms. Panfield to suggest, in the light of the judgment of Mr. Justice Collins and his colleagues, that anything like this paper disposal by Mr. Justice Field somehow legitimised the decision to prosecute.
Well, if Mr. Justice Field had heard the argument and had the pre-reading, for example, that Mr. Justice Collins had been able to do and heard the argument that he heard, the outcome would obviously have been different, I say. But I did want the court just to see exactly what he said, because I think Ms. Padfield's point is going to be that the operative effect of any discrimination can't have continued after the imprimatur of Mr. Justice Field by refusing to strike it out. I think that's what's said. I'll, of course, wait for her to put her own case in her own way, but I did want the court to see what Mr. Justice Field said about the application to strike out. It's at paragraph 4. Ms. O'Connor goes on to advance legal submissions as to why her actions do not breach the Code of Conduct of the Bar of England and Wales. The Bar Standards Board advances responsive written submissions. In my judgment, Ms. O'Connor's submissions fall well short of demonstrating that she has no case to answer. This is not to say that ultimately it might be held that those submissions are correct, but the determination of that question is for the disciplinary tribunal at a full hearing of the charges, not for a procedural tribunal dealing with an interlocutory strikeout application. There's a mistake in that sentence. I think it must be, this is not to say that ultimately it might not be held. It should be a double negative, I think. But the point I'm making is that he just said that a submission of no case is for the tribunal.
Might be held that that's correct. What was a not missing? Anyway, matters not. We know what's being said.
Yes, I'm not sure. So that ruling gives no legitimacy to this prosecution that it didn't otherwise have. If the decision to prosecute the appellant was the result of systemic bias, that bias didn't come to an end with the tribunal's verdict, but informed the decision to prosecute the rehearing on appeal as well. I'll come to the meaning of rehearing in a minute. As I said already, the appellant was a victim because she was the subject of disciplinary proceedings. The appeal to the visitors was opposed and the victim status persisted. A couple of examples might assist. Suppose that the Bar Standards Board had lost before the tribunal and had exercised its limited right of appeal. Or suppose that we're not talking about bar disciplinary proceedings, but some other sort of proceedings where there is a full prosecution right of appeal. No one would say, would they, that the exercise of that right of appeal by the prosecution would be anything other than a furtherance of the prosecution. A second example, what if the visitors had ordered a rehearing, which they had power to do? Would the three proceedings, that's to say the first prosecution to conviction, the proceedings on appeal, and then the second proceedings to conviction or acquittal, would that be three proceedings with three limitation periods? But the only reason for concluding that was if somebody wants there to be three limitation periods because they want some claim arising out of those proceedings to be statute barred. These examples we submit, show that the outcome that the Court of Appeal favoured could result in other cases in all sorts of difficulties of analysis that the outcome which the appellant seeks this court to substitute does not. It would be clear that, and consistent with the Strasbourg approach to matters, to say that you start your human rights claim when what used to be your domestic remedies, and now your quasi-domestic, well, it's still a domestic remedy, but I think the court knows what I mean. When you've sued for all you can before you get to the Human Rights Act, or in this case, you've exhausted your appeal. If the proceedings are regarded as one, and the limitation period starts with the end of the proceedings, then all of these problems about rehearings and retrials and prosecution appeals simply don't arise. And they would only arise in other future cases if this court allows the Court of Appeal's false distinction between a prosecution and an appeal to stand. It's a distinction we submit, partly based on a departure from the language of the Act and from the Convention. What the Court of Appeal, if we look at Lord Dyson's judgment at paragraph 16, 173, he formulates the question in a peculiar way, we submit. In my view, these cases are... Montgomery and H.M. Advocate are of little assistance, he says. That's something from which we would not dissent, and I haven't cited them. But he says the question is whether a prosecutor's opposition to an appeal by a defendant following a conviction amounts to the continuation of the act of initiating the prosecution. And Lord Justice Elias, at paragraph 37, which is page 178, says something very similar in the third line of his judgment. The decision to resist an appeal cannot sensibly be seen as a continuation of the original decision to prosecute. We submit that once you've concluded, as the Court of Appeal was rightly inclined to do, that a prosecution is a single continuous act, it's unnecessary and potentially confusing to ask whether each step in that prosecution is a continuation of earlier steps. We submit that each step is a continuation of the process, not a continuation of earlier steps in the process. So serving a list of documents in a civil action, for example, is a continuation of the claim, but isn't a continuation of the act of issuing the claim form. That's the reason for our limited concession in paragraph 13 of the printed case, which Ms. Padfield would have as an important concession in paragraph 24. 129. Concession is at 129, very limited. Having made the point that I've just made orally, we say it may well be, at the end it may well be right that taking a decision to resist an appeal is not a continuation of the act of instigating the prosecution. Even so, resisting the appeal is an integral and necessary aspect of the process of prosecution.
Yes, because you're saying you're not complaining about the act of instigating the prosecution alone. You're complaining about the whole prosecution process.
Yes, that's right. And so that is not an important concession, if concession is the right word at all. It merely intended to reinforce the point that we were making. But if one does look at the words of the convention rights that are in issue here, this is in Authorities Volume 1, Tab 1, and that is page 566. Article 6, at the bottom of the page. In the determination of his civil rights and obligations, everyone is entitled to a fair and public hearing, etc. What is an issue in this claim is whether the claimant was allowed a determination of her civil rights and obligations, or to use the words of Article 14, which is at page 569, in the enjoyment of her rights and freedoms, whether in the determination of those matters there was or was not discrimination. Disciplinary proceedings involve determination of her civil rights and obligations, and we say they are not determined until after the appeal has run its course. Can we look at Delcourt and Belgium, which is in page 1099, 1099, behind tab 15 of volume 2. And this is paragraphs 24 and 25. Now, it's fair to say at the outset, when looking at this case, that the European Court of Human Rights was not addressing whether an appeal was part of the prosecution or separate. It was, as Ms. Padfield rightly points out, it was examining whether the Article 6 procedural guarantees apply to an appeal or not. So there's a slightly different question, but we submit that the reasoning of the court is highly material, it's persuasive, that it should be, that we would commend it to this court, and if this court accepts that reasoning, then it has a heavy impact on the outcome of this appeal. If we start at paragraph 24, the context of this was an appeal to the court of I hope there's an English word, cassation, but that's the word. That's how I propose to pronounce it anyway. An appeal to the Court of Cassation in Belgium, in circumstances where that court isn't allowed to have regard to the merits of the dispute upon which it's being asked to rule. It can only quash or affirm decisions based on procedural or other matters not related to the merits. And therefore, the government was, what had happened was that somebody allegedly from the prosecution had gone and helped the Court of Cassation with the law in private. And so it was alleged that that breached Article 6 rights. And the government was arguing, well, it's not really part of the process below, and it's the Article 6 rights don't have to apply in these circumstances. Paragraph 24, the government's arguments are based essentially on the words bien fondé de toute accusation in the determination of any criminal charge against him, which delimit the scope of the application of Article 6 in criminal cases. Article 95 of the Belgian Constitution provides that the Court of Cassation does not deal with the merits of the cases submitted to it. Accordingly, in the government's view, there is not, strictly speaking, a prosecution or a defence before that court. Prosecution and defence cease to exist the moment that the judges dealing with the merits give judgment in final instance, subject to the possibility of their being reborn in the event of the Court of Cassation referring a case back to a lower court after quashing the decision attacked. We can skip the next bit. Paragraph 25, the court cannot accept this view. Judicial decisions always affect persons. In criminal matters especially, accused persons do not disappear from the scene when the decision of the judges at first instance or appeal gives rise to an appeal in cassation. Although the judgment of the Court of Cassation can only confirm or quash such decision and not reverse or replace it, I pause there, unlike in this case, of course, that judgment may rebound in different degrees on the position of the person concerned. He loses his status of a convicted person, or as the case may be, the benefit of his acquittal, at any rate provisionally, when a decision is set aside and the case is referred back to a trial court. A judgment in cassation sometimes has even more direct repercussions on the fate of an accused. If the highest court dismisses the appeal in cassation, the acquittal or conviction becomes final. So that was part of the reasoning, but then after the word besides, halfway down the page, there is some further reasoning based on the English text of Article 6. Besides, the court notes that that in fact the English text of Article 6 does not contain any term equivalent to bien fondé. It uses the much wider expression of determination of any criminal charge. Thus, a criminal charge is not really determined as long as the verdict of acquittal or conviction has not become final. Criminal proceedings form an entity and must in the ordinary way terminate in an enforceable decision. Proceedings in cassation are one special stage of the criminal proceedings, and their consequences may prove decisive for the accused. It would therefore be hard to imagine that proceedings in cassation fall outside the scope of Article 6.1. My lady, one can transpose some of those words to this case as follows. Disciplinary proceedings form an entity and must terminate in an enforceable decision. Proceedings before the visitors are one stage of the disciplinary proceedings, and their outcome will be decisive for both the BSB and the accused. In other words, the will be and decisive for both parties make this an even stronger case than Mr. Delcourt's. So if the propositions are accepted, we submit that they are heavily persuasive of the issue whether the appeal is part of the prosecution. Article 6 focuses, as I say, on the determination of the charge. And if that charge is determined on appeal, the appeal must be part of the same process as the first instance proceedings.
Mr. Anderson, you said, is it part of the prosecution? This word prosecution, Lord Dyson says, well, is it part of the prosecution? No, I don't think it is. Ms. Padfield says, not part of the prosecution. I mean, what's the magic in the word prosecution here? Where do we get it from? Why are we limited to shoehorning or otherwise the appeal to the visitors into whether it's a part of the prosecution?
It's part of one process, and if
I mean, the decision was to take and maintain disciplinary proceedings.
Yes.
But if that's the right analysis, then the appeal to the visitors is clearly part of that.
Right, so, yes. The prosecution, of course, it can be misleading for a much less important reason, which is that it's a criminal word usually, but the prosecution of any proceeding, civil or criminal, is something that takes place over a period of time. And I gratefully accept the point that if one uses it to mean something more technical and then uses that to create a distinction between that and the appeal, then you can be creating distinctions which are purely based on the way you choose to use words and which don't actually have any basis in the substance of what you're trying to talk about. Yes. There's a very similar passage to the language of Delcourt at paragraph 75 of Her Majesty's Advocate in the Crown. Well, it won't take long. I think we should perhaps refer to it. It's tab 9 of the first bundle, 872. Perhaps you could just shout out the page numbers.
I'm sorry, can you give me the page number again, please?
872, my lord.
Okay.
This was a claimant who'd been charged with indecency offences in 2001, alleged to have occurred in 1995. So the issue was unreasonable delay. And the issue was whether it was necessarily in breach of Article 6 to continue proceedings after a delay, an unreasonable delay had already occurred. The House was split on that issue, but they were unanimous on the issue of whether a prosecution was an act. The ratio of the case doesn't help us as to whether a prosecution is a continuing act, nor whether it includes an appeal. But the dicta of Lord Hope at paragraph 75, which contributed to his reasoning, we submit correct and are informative as to what the outcome of this appeal should be. He says, in my opinion, the proper starting point for an analysis of all the Article 6.1 rights is to be found in the wording of that article. It's important to put the words "a fair and public hearing within a reasonable time" into their right context. That context is to be found in the opening words of the article. It begins by identifying the proceedings in which everyone is to be entitled to the protection of these rights. They are proceedings for the determination of his civil rights and obligations, or of any criminal charge against him. It has been held that the reasonable time guarantee begins to run as soon as a person is charged within the meaning of the Convention, ECLA and Federal Republic of Germany. The wording of the article indicates that it continues until the charge has been determined. It includes the whole of the proceedings which are designed to achieve that purpose, including proceedings on appeal. It's been held that the purpose of the guarantee is to prevent an accused person from remaining too long in a state of uncertainty about his fate. Sturgmüller and Austria. That decision indicates, as do the opening words of the article, that the guarantee relates to the proceedings as a whole. It is the time taken by the proceedings overall that matters. The guarantee does not concern itself with parts of the proceedings in isolation from other parts. Lords, those words speak for themselves. I invite this court to say that that reasoning is all correct and does inform the outcome of this appeal. Now, my lady, permission was granted for this appeal with the observation that the court may think that the nature of the visitor's hearing, see paragraph 12 of their judgment, is relevant. That set us off into the books, and in our printed case at paragraphs 21 to 22, we set out something of the history, functions of the visitors. Page 131, thank you. I don't propose to develop those points in oral submissions because I'd simply have to read them out, and I don't think that would help. The submission is, it's only part of a wider picture. It's perhaps more important that the nature of the appeal is a rehearing, which I'm going to come to, but the submission based on the history is that the appeal jurisdiction, certainly at the time we're looking at, was merely part of a wider supervisory jurisdiction by the judges of the High Court, and that it would be artificial and wrong to treat the appeal as separate from the prosecution. It's notable that Mr. Justice Field gave directions for the trial of an issue before a tribunal, consisting of much less elevated, in judicial terms, members. And that merely illustrates that the judges had their hands on this matter from start, and it was they who got the right outcome in the end as well. So that's part of the background. And those three cases that we've cited, Re-S, Ex parte Calder, and two cases, are quite informative about that history. I should say that it's changed now, and it's now an appeal to the High Court as a High Court. So it's not a point that would any longer be available, but it is available in relation to this case. But the main point really is that an appeal to the visitors is by way of a rehearing, as was established in Calder. At quite a late stage, for which apologies, we thought it was necessary to give the court a bit more help on what that actually means in practice. And so we photocopied the case of Ghosh and the General Medical Council, which is in the supplemental bundle again. It's at page 35 of that bundle, the relevant passage. Page 42. This obviously wasn't the visitors, it's a different tribunal, but there is a discussion of what the implication was for Dr. Ghosh of the fact that his appeal was to the Privy Council on this occasion was a rehearing, and so it is relevant to that question in this case. Just above letter H.
On
page.
Sorry, page 42.
Paragraph number
31.
31.
Yes.
Thank you.
But 1, 2, 3, 4, 6 lines in. With this in view, that's counsel for Dr. Ghosh, reminded their lordships that proceedings against a registered practitioner for professional misconduct involve a determination of his or her civil rights and obligations and accordingly attract the protection of Article 6. Such protection requires either that the decision-making body, in this case the committee, constitute an independent and impartial tribunal, or if not, that its processes be subject to control by an appellate body with full jurisdiction to reverse its decision. Those submissions were not disputed by the Council, and the Lordships accept them. Council next submitted that the committee was not an independent body, and that accordingly the board must take an expansive jurisdiction when hearing appeals from the committee if a breach of convention was to be avoided. Didn't find it necessary to decide that because they're satisfied that their own jurisdiction is sufficient to remedy any deficiency there may be. Paragraph 33. Practitioners have a statutory right of appeal to the board under Section 40 of the Medical Act 1983, which does not limit or qualify the right of the appeal or the jurisdiction of the board in any respect. The board's jurisdiction is appellate, not supervisory. The appeal is by way of a rehearing in which the board is fully entitled to substitute its own decision for that of the committee. The fact that the appeal is on paper and that witnesses are not recalled makes it incumbent upon the appellant to demonstrate that some error has occurred in the proceedings before the committee or in its decision, but this is true of most appellate processes. It is true that the board's powers of intervention may be circumscribed by the circumstances in which they're invoked, particularly in the case of appeals against sentence, but their lordships wish to emphasise that their powers are not as limited as may be suggested by some of the observations which have been made in the past. He then quotes from another case in which it was suggested that particular regard has to be given to the disciplinary tribunal's decisions on sentences. And he goes on at G, for these reasons the board will accord an appropriate measure of respect to the judgment of the committee, whether the practitioner's failings amount to serious professional misconduct, and on the measures necessary to maintain professional standards and provide adequate protection to the public. But the board will not defer to the committee's judgment more than is warranted by the circumstances. The Council conceded, and their lordships accept, that it's open to them to consider all the matters raised by Dr. Ghosh in her appeal, to decide whether the sanction of erasure was appropriate and necessary in the public interest, or was excessive and disproportionate, and in the latter event either to substitute some other penalty or to remit the case. And if we look in the same bundle while it's open at page 28, this is an excerpt from the White Book. Your Lordships your Ladyship will be aware that the rules provide that an appeal to the Court of Appeal will be by way of a review unless the court otherwise orders. And so there is a discussion in the notes to Rule 21 about what the difference is between those two creatures. I hope that your ladyship's paper copies are marked with a line.
Yes.
On page 29 of the bundle, shortly after Part 52 of the CPR came into effect in Tanfern and Cameron MacDonald, the Court of Appeal explained at paragraph 31 that in combination with paragraphs 1 and 3 of Rule 21 marked a significant change in practice in relation to what used to be called interlocutory appeals from district judges or masters. Under the old practice, the appeal to a judge was a rehearing in the fullest sense of the word, and the judge exercised his/her discretion afresh while giving appropriate weight to the way the lower court had exercised its discretion in the matter. Under the practice which came into effect in May 2000, the decision of the lower court attracts much greater significance. Generally, the appeal court's duty is limited to a review of that decision. It may only interfere in the quite limited circumstances set out in paragraph 3. At the bottom of the page, the decision of the Court of Appeal in Assicurazioni Generali, an Arab insurance group, contains a thoughtful discussion as to what the difference is between review and hearing in the context of Rule 52.21. Both Lord Justices Clark and Ward conclude that in a case where the appeal court is being asked to reverse findings of fact based upon oral evidence which the judge has heard, the approach of the appeal court is the same whether it proceeds by way of review or rehearing. On the other hand, where the judge's evaluation of the facts or exercise of discretion is challenged, then the difference between a review and a rehearing will be of considerable importance. In Datec Electronic Holdings and United Parcels, the House of Lords approved the judgment of Lord Justice Clark in Generali. And then the matter was reviewed in DuPont and DuPont, turning over 5 principles emerge. Because the rule applies to a wide range of possible appeals, it contains a degree of flexibility necessary to enable the court to achieve the overriding objective of dealing with individual cases justly. In other words,
You're not going to read all this out, are you?
Well, I was worrying how much to read. The trouble is that if one doesn't, then one can be accused of not being complete in the sense of reading the bits that suit one's case and not the bits that don't.
You can refer it to us and we can read it.
I appreciate that, and I was toying with inviting the court to do that, but I'm grateful for the interruption. The passages that we rely on are marked, and yes. I won't read them.
Yes, very helpfully marked, and thank you very much indeed. And I assure you that we shall read them.
Now, one small point, the visitors, of course, do share the expertise of the disciplinary tribunal in this particular context that we're talking about. So they are in just as good a position as the disciplinary tribunal, if not better, to understand the profession that they are supervising. So there is no reason to give any special respect to the tribunal on those grounds. Now, so what do we distill out of all of that? We say two things. Firstly, the visitors had to come to their own decision on the issues and not merely review the tribunal's decision. But secondly, the charges had to be proved, again, to the satisfaction of the visitors. In Calder, at paragraph 62G, I won't go to it this time, 1029, one of the observations made by the Court of Appeal in that case was that if the experienced judges had appreciated that they had to decide if the matter had been proved against Miss Calder on the criminal standard, they would, as experienced judges, have said so, and they didn't. It was one of the reasons for allowing the appeal. The extent of the rehearing, of course, does depend, as was observed in the note I read out, on what's gone wrong in the court below. And the degree of respect to be afforded to the decision of the court below depends on the extent to which the court below adopted a fair procedure to reach its findings. But what does emerge from Lloyd and McMahon, the Liverpool councillor's case, is that the appeal can put right serious procedural defects in the decision below. And in this case, there were serious procedural defects, which meant that until the hearing before the visitors, the disciplinary proceedings could not be said to have reached a satisfactory conclusion at all. Not only were they wrong, but the procedure was so flawed that they were as good as useless. If we look at the decision, the judgment of the visitors, page 216. Paragraph 10. Mr. Justice Collins describes the procedure that took place. The appellant gave evidence on her own behalf and was cross-examined by counsel for the BSB. Following the conclusion of his cross-examination, the tribunal adjourned for lunch. When they returned, the chairman announced that the charges 1 to 5 had been proved. Last 3 lines, it is said on her behalf that there was in those circumstances unfairness because it was a breach of what are compendiously called the rules of natural justice to have failed to grant her the right to comment. Prima facie, there is considerable force in that submission.
Why are we going into this, bearing in mind it was all parked, Mr. Anderson?
Because it demonstrates that the importance of the appeal to the determination of the appellant's rights and freedoms. This litigation, to use a compendious phrase, wasn't front-loaded, as is the current fashion. This litigation was back-loaded. All the important business took place at the end. What took place before the disciplinary tribunal in this case couldn't possibly have stood on procedural grounds. I know that the visitors didn't decide that, my lord, but that's my submission, that it couldn't have stood if there hadn't been other flaws in it anyway. And that, therefore, the really important proceedings in this case, which the BSB prosecuted against our client, was in fact the appeal. That's the point I'm making.
But you don't really want us to say that because the procedure before the tribunal was so unsatisfactory, the appellate process is part of the prosecution process. But if it had been satisfactory, it wouldn't be. You don't want us to say that, do you?
No, of course not. No, but each case
I think
depends.
it's behind my lord's court.
Each case depends on its own facts, of course, and the facts in this case include that, as I say, all the important litigation took place at the last moment.
I think your point is that because there was, in your submission, a patently deficient proceeding before the tribunal, that emphasises the circumstance that there hadn't been a determination of Mrs. O'Connor's
My lord, yes.
rights. Yeah.
Yes.
Doesn't necessarily mean that if there had been a proper proceeding, that there still wouldn't have been a determination.
Part of the picture. And it just, even without demonstrating that things went badly wrong in this case, the fact that in disciplinary proceedings you have to have an appeal which can cure procedural defects makes that appeal much more important than an appeal that can't. And we submit that that is a factor to be taken into account. Again, really, it's the consequences of trying to divorce the appeal from the first instance proceedings that I'm talking about. If the appeal can put right procedural defects at first instance, then surely the two are not separate and distinct procedures. They're all part of the same process, which, as my lord says, is determining the whether the defendant is guilty or not. But in this case, the fact was, and I think that this is an important point, what happened here before Mr. Justice Collins was a complete rehearing, in the fullest sense, as the courts have described it in the past. If there had been, if there had been live evidence, this hearing was the equivalent of having it again. I mean, Mr. Justice Collins and the visitors simply heard argument again and gave a verdict, which this time was the correct one. In other words, really, going back to the dicta that I cited from Delcourt, This case is Delcor with gold plating. We say that it strongly illustrates those principles that were enunciated in Delcor. There is another point, related but separate, which arises from the absolute nature of the right of appeal. You don't need permission to appeal from a disciplinary tribunal. You had a right to go to your visitors of your inn. The verdict of the disciplinary tribunal, therefore, cannot take effect if there is an appeal until after the appeal has been determined. The procedure is, or at least was, that the sentence that the disciplinary tribunal decides upon is actually pronounced by the benches of the inn.
It's pronounced by the Treasurer.
Treasurer, I'm so sorry. Yes.
I have every reason to know that.
Yes, I imagine that you've...
Unimpeachable authority.
And indeed you do, even under the new system, have to wait until the time for appealing has elapsed before you can do so.
The point I'm making is clear, I hope. There's no stay of execution required. The sentence cannot be pronounced until the appeal has run its course. I come now to the practical considerations. I've perhaps got about 10 minutes left, I think. Practical considerations.
Well, you need to leave yourself, you indented for 2 hours with a 20-minute reply, but you need to leave a considerable part of your 2 hours in case you have to reply.
Coming towards the end. Yes. The chronology here was that the tribunal verdict was on the 8th of June 2011. The appeal was determined on the 17th of August 2012. And the implication of that is that the claimant would have had to have started this action before the appeal had run its course, if the Court of Appeal's decision is right. So she would have had to start proceedings before the 8th of June 2012, and the appeal was heard in August 2012. That would have been deeply unsatisfactory. Opponents faced with such proceedings, I don't know whether the BSB would have taken this position or not, but opponents faced with such proceedings are not always as cooperative as Mr. Justice Warby assumed when he said, well, you should just issue proceedings and have them stayed, or secure an agreement to stop the limitation clock running. The arguments available to a defendant faced with proceedings before the appeal has been allowed, proceedings by a convicted defendant, their only arguments available, but they would be available, are that, well, this is a collateral attack, an abuse of the process of the court, or of the tribunal, well, of the court, sorry. There would be the argument, you have no victim status because you were guilty, and the court has to presume that you were guilty, and a person who starts proceedings when they've no cause of action vested in them is guilty of an abuse of process. Witness the cases where people who are going to take an assignment of a cause of action start the proceedings to stop the limitation clock running. So those are the sort of arguments that would have been available to a defendant faced with the premature proceedings that the Court of Appeal's decision would have necessitated. I'm not submitting that it would have been an abuse of the process. I'm not submitting that it would have been an abusive collateral attack. I'm submitting that those arguments would have been available to some insurers, some defendants, that you cannot always expect defendants to be cooperative in agreeing to a stay. It's quite possible that you apply to the court for a stay of your proceedings because you've issued them, and you'll meet with the argument that you've issued too early. And then costs are run up. You've got the practical consideration that this claim form costs £465, but some claim forms cost £10,000. All of these considerations don't arise if you simply accept that you don't have to start your Human Rights Act proceedings until the proceedings that they're about have run their course, which makes perfect sense, I submit. And those practical considerations militate in favour of reversing the Court of Appeal's decision. In short, my lady, we submit that once it's accepted that a prosecution, that disciplinary proceedings are a continuous single process, then it's impossible to say that it doesn't include the appeal. One final point. It is said that this appeal isn't open to the appellant at all because the Court of Appeal and Mr. Justice Warby said that there was no allegation of discrimination in relation to the appeal. It's perhaps well to look at Mr. Justice Warby's judgment at paragraph 74. Page 200. We need to look at the submission that he was rejecting. At the beginning of the paragraph, he says, however, I reject Mr. Southey's submission that the particulars of claims state further and broader claims which are adequately pleaded and have a real prospect of success and therefore ought to have survived the hearing before the master. Number two, there is no pleaded case that the BSB behaved in a discriminatory manner in respect of the appellant's appeal. She does plead that BME barristers are more likely to have convictions upheld, but decisions on appeal are the responsibility of the visitors and not the BSB. The pleaded case appears, moreover, to be based on a misreading of the diversity review report, which makes no reference to appeals. The report contains nothing to support any allegation that the BSB makes a practice of treating BME barristers less favourably in relation to appeals. And the Court of Appeal repeated at paragraph 22 that there was no allegation in relation to the appeal. Of course, what Mr. Southey was submitting was that there was a separate allegation in relation to the appeal. Mr. Justice Warby having found already at this point in his judgment that there was a properly, well, if not properly, a sufficiently pleaded case based on Article 14 and 6 in respect of the disciplinary proceedings as a whole. I mention this because in the Respondent's printed case at paragraphs 12 to 13, this observation by Mr. Justice Warby that there is no pleaded case that the BSB behaved in a discriminatory manner in relation to the appeal has far more weight placed on it than it's capable of bearing. That part of Mr. Justice Warby's judgment was the subject of a ground of appeal to the Court of Appeal. And I'd invite you to look at page 391, please.
$391?
Yeah, I must have got that wrong, so I'm so sorry. 38. It's Appendix 2, page 226. I thought I'll add 2 notes. Grounds of appeal are at 4. 4.1, permission was refused. 4.2, permission was refused. Over the page, 4.3.
Sorry, Mr. Anderson. It's Appendix 2, page 390?
227, my lord.
227.
390 of them.
Very sorry. Thank you very much.
Electronically. The ground of appeal upon which permission was granted was failing to take adequate account of the fact that the proceedings that resulted in the claim were only concluded less than a year before the claim commenced. And we submit that that plainly was a ground of appeal that entitled the appellant to argue before the Court of Appeal and before this court that the appeal is included in the compendious phrase, the prosecution or the proceedings. And insofar as, if Mr. Justice Warby was meaning to say in paragraph 74 that the appeal was not part of the overall proceedings, then this is an appeal against that finding. Those are our submissions.
Thank you very much indeed, Mr. Anderson. Mr. Shelvan, you? Miss Padfield.
Lady, you have invited us to deal with the time point before dealing with what one might call in shorthand the respondent's notice.
Yes, or indeed cross-appeal. It's not technically a cross-appeal, but it is a cross-appeal, basically. So, anyway, we would like you to deal with limitation first.
In order to deal with the limitation point, it is, however, necessary to look at the legal nature of the one remaining act complained of by the claimant and to some extent the evidence on which it is based, because the respondent's case is that those are necessary elements when one comes on to consider how Section 5A is applied. So I will need to address those to some extent. If I could start with the nature of the claim which survives. My lady, my learned friend, I think, left us in the core volume on page 200.
What are you taking us to?
My lady, at paragraph 73, one sees Mr. Justice Warby's description of what he describes as the one claim, essentially, which he finds adequately pleaded and not fanciful, by which he means, of course, supported by sufficient evidence as to have a real prospect of success in the judgment application. And he says that he's concluded that the particulars of claim in their unamended and draft amended form, that there's no point about the draft status of the amended particulars of claim. He says they adequately state a case which is not fanciful, that by bringing disciplinary proceedings against the appellant, the BSB indirectly discriminated against her contrary to Article 14. And he deals with that plea, or that claim, in his judgment under a heading on page 195 of the Article 14 claim.
Sorry, page.
It can't be that. What's the electronic number?
What? 195, my lady.
Which paragraph of the judgment, please?
Paragraph 54.
54. That is 195.
And my lords and my ladies will see there that Mr. Justice Warby says, after describing Article 14, he talks about a complaint falling within the ambit of another right. That other right, of course, here is Article 6. And he says, at the risk of oversimplification, the appellant's case as presented by Mr. Southey on this appeal can be summarised in this way. Point 1, the claim is that the BSB has indirectly discriminated against her in respect of her Article 6 rights. And point 2, a claim for such indirect discrimination may be made under Article 14, as established by the decision of the Grand Chamber in DH and Czech Republic. And then he goes on to consider, in a passage which will become relevant if we go on to consider the Respondent's notice point, at paragraphs 65 and 66 on page 198, the evidence on which the claimant says the test in DH can be satisfied for the purposes of this claim. And my learned friend has taken the court to paragraph 74, where Mr. Justice Warby says, I reject Mr. Southey's submission that the particulars of claims state further and broader claims which are adequately pleaded and have a real prospect of success, and therefore ought to have survived the hearing before the master. And those claims as pleaded are at pages 300 and 302 to 303.
When Mr. Justice Warby says at 74.2, there is no pleaded case that the BSB behaved in a discriminatory manner in respect of the appellant's appeal, is Mr. Justice Warby meaning there is no pleaded case that the BSB behaved in a discriminatory manner in respect to the appellant's appeal taken on its own?
My Lord, yes, he's looking at the evidence of discrimination, the evidence of indirect discrimination, which in this case goes only to the decision to refer BME barristers to a disciplinary tribunal and the fact that they were statistically more likely to be referred.
Isn't the case that the discrimination continued from start to finish, the finish being the verdict of the visitors?
My Lord, I say not, for reasons that I will develop. If this had been a claim of direct discrimination against the claimant, that might well be the case, but it isn't. It's important to focus on the nature of the claim being brought by the claimant.
Do we need to draw a very sharp distinction between direct and indirect discrimination for the purpose of Article 14? Article 14 is not the same as the Equality Act. It doesn't contain precise definitions of direct and indirect discrimination. There are several differences from the Equality Act. Under the Equality Act, there's direct and indirect discrimination, and you cannot have them both at once. I'm not myself sure that Strasbourg draws quite such a sharp distinction between direct and indirect discrimination. Undoubtedly, in DH, they relied on the statistics to say they must be discriminating against the Roma children because look where they put them all in school, so disproportionately. But that wouldn't necessarily rule out some actual direct discrimination against the Roma children, would it?
No, my lady, I accept that. But the basis on which the claimant's claim in this case is put is indirect discrimination on the basis of DH. That's the basis on which it was put below. I would like to come back in a moment to the way the case is pleaded, although perhaps actually let me do that and then I will address that point further. The way the Article 14 claim was pleaded originally is at page 300. My learned friend took the court to paragraph 22, where there's a reference to Article 14. And then, as he said, the first allegation of not being allowed sufficient time to prepare, the allegation of discrimination in relation to that claim is no longer live. There's a reference there to the defendant's general complaints process impacting disproportionately on black and ethnic barristers. And then there is the gist of the claim. Black and ethnic barristers are more likely to have a complaint referred for disciplinary action, are more likely to be convicted, and are more likely to have those convictions upheld. The claimant avers that the fact that every element of the defendant's disciplinary system impacts on black and ethnic barristers more adversely indicates that there is a systemic bias against black and ethnic barristers. And then at paragraph 24, there is the list of factors which Mr. Justice Warby refers to. And the first is more likely to be investigated following a complaint. The claimant's complaints of investigation in the second and third complaints that were made against her were rejected by Mr. Justice Warby, so that those have gone. More likely to have a complaint referred for prosecution. That is the element of the claim in respect of which there is evidence that BME barristers were referred in proportionately greater numbers than white barristers. More likely to be prosecuted. There's no evidence of that separate from more likely to have a complaint referred for prosecution. So insofar as that's said to be something separate, Mr. Justice Warby didn't make a finding that there was evidence on that. More likely to be convicted and more likely to have those convictions upheld. More likely to be convicted is the subject of evidence, but of course that's an act not of the respondent, but of the disciplinary tribunal, which is an independent and separate body. And then more likely to have those convictions upheld, Mr. Justice Warby says correctly and in a finding which hasn't been appealed, that there's no evidence of that in the report which is relied upon, which is the evidence on which the claimant relies. So that's the plea. And so the fact that at paragraph 23 at the end there's a plea of systemic bias, I say is important when one goes back to look at Mr. Justice Warby's judgment at paragraph 74 on page 200, because he expressly rejects there Mr. Southey's submission that the particulars of claims state further and broader claims which are adequately pleaded and have a real prospect of success. And so the only claim that survived after the hearing before Mr. Justice Warby was that he uses the expression in paragraph 73 by bringing disciplinary proceedings against the appellant. The evidence there is in respect of referring a BME barrister to the disciplinary tribunal, so effectively preferring charges. So that's what that relates to. My learned friend took you to paragraph 74 too, so I won't take you to that again, but that's where Mr. Justice Warby says what the content of the one surviving claim is. And if I could ask the court to look at the notice of appeal to the Supreme Court in this case, which is at page 24.
I'm sorry, page?
It's actually 21 that I would like you to look at, page 21. My Lord appears to be having difficulty hearing me.
I am having difficulty hearing you, I'm sorry.
So am I.
Speak up, Miss Padfield. The
I will.
Microphones are there for recording and transmitting purposes.
But
They're not there to amplify. They have a slight amplificatory effect, but they cannot be relied upon.
I'm grateful. I will speak up. Please do tell me if my voice
Mr. Anderson had exactly the same problem, so you needn't feel discriminated against.
I don't feel discriminated against at all, but I am concerned that my submissions may not be being heard, which is obviously...
Well, I tell bar students when I meet them at Gray's Inn that the first duty of any advocate is to be heard.
I don't dissent from that, my lady. I'm grateful for the advice.
We're lucky on this side because we can hear you.
I may have to move further into the middle if the problem persists, but I will
move.
try.
Don't move away from us, please.
No.
Page 21, this is the appellant's notice of appeal, in fact, notice at that stage of application for permission to appeal to this court. In dealing with the judgment of Lord Justice Elias, Mr. Southey says below the, actually at page 20, so paragraph 6.17, Mr. Southey says, Lord Justice Elias acknowledged that the claim was essentially a systemic challenge. That was clearly correct. The appellant relied on DH and Czech Republic. In that judgment, the European Court of Human Rights considered the extent to which statistics could be used to demonstrate that a rule that was superficially neutral was operated in a discriminatory manner. The court reached the following conclusions, and he summarises those. I don't need to go through those. And then he says, this demonstrates that it was the systemic issues that were demonstrated by statistical evidence that gave rise to, I should say, the claim. The arguments that the appellant relied upon could have been raised by any BME barrister subject to disciplinary proceedings brought by the respondent. And then at paragraph 6.18, he talks about victim status, and he says, about halfway down, it was only the disciplinary proceedings, including the appeal, that caused the appellant to be a victim. The appeal caused the appellant to be a victim as she continued to be affected by the disciplinary proceedings while the appeal was resisted. So the reason that I'm taking the court to those points is that the basis of this claim is that any BME barrister who was prosecuted in the period covered by the evidence in the report relied on by the claimant could, on the claimant's case, have brought a claim. It's a claim for indirect discrimination based on statistics which show disproportionate numbers were prosecuted. It is not a claim, although my learned friend has taken the court to allegations of things that went wrong in the claimant's prosecution, which he says were put right by the visitors. But that is not the nature of the claim for indirect discrimination under DH. And in terms of the claim for indirect discrimination, its nature is an indirect claim rather than a direct claim. If I could ask the court to turn back to the draft amended particulars of claim at page 302, at the bottom of the page. And the court will see there, paragraph 29, the plea is under the heading direct and indirect discrimination. The defendant discriminated against the claimant indirectly in breach of various provisions that are no longer relevant, and Article 14 of the Convention. And then the specific plea is the defendant's rules are applied in such a way that although the code of conduct of the bar applies to all barristers in England and Wales, it particularly disadvantages ethnic barristers who make up only a small proportion of the membership of the bar. And then there's a reference to paragraph 20, which is in fact facts in relation to the misfeasance claim, and which we say do not form any part of the ingredients of the cause of action for indirect discrimination under the DH criteria. So what the claimant is claiming is that apparently neutral rules in relation to disciplinary matters are applied by the respondent in a way which particularly disadvantages BME barristers, although she doesn't ever say in what way they do. And she supports that claim of indirect discrimination by reference to the disproportionate numbers of BME barristers who are referred to the disciplinary tribunal. So that is the evidence. Turning to the Strasbourg case law to see what the ingredients are of indirect discrimination based on DH, there is, as the court will be aware, a series of cases involving the treatment of Roma people, and in particular Roma children, in terms of education. One of these is DH, and there are others which are in the authorities bundle and to which I would like to turn briefly, including Ursus and Croatia. It's plain, and we say that this is relevant because the notion of indirect discrimination is not particularly well developed in the case law of the Strasbourg court. We say that the context and the way in which the claim of indirect discrimination has been found in the previous cases illuminates what is required for there to be a finding of indirect discrimination. And the starting point is that there is a significant emphasis in this line of case law on the special protection required for Roma people because, as the court says in the DH case at paragraph 182, which is page 1246, if the court wishes to look at it, as a result of their turbulent history and constant uprooting, the Roma had become a specific type of disadvantaged and vulnerable minority. And there was very extensive material considered by the court in the DH case supporting the parlous situation of Roma people and in particular Roma children in terms of education in different parts of Europe. Obviously in DH it was the Czech Republic in particular.
Ms. Padfield, it would assist me enormously if at some point while you're dealing with this topic you could assist me in relation to the distinction drawn by Lord Justice Elias at paragraph 38 and following his judgment. At some point, I don't want to take you out of your order.
I'm grateful, my lord. And for example, I don't need to take the court to it. At paragraph 115 in the case of Horvath and Hungary, which is page 1358, I've set this out at footnote 55 in the respondent's case, which is page 156. The European Court of Human Rights notes that the misplacement of Roma children in special schools has a long history across Europe, and then talks about the concepts that were applied in some cases in order, or not in order is may or may not be correct, but which resulted in Roma children being treated effectively as though they had a mental impairment when they didn't. So, for example, the concept of familial disability was applied in Hungary. And so the DH case itself involved an apparently neutral measure which put Roma children at a particular disadvantage when compared to non-Roma children. And my lady, Lady Hale, referred to the statistics that were used in the DH case. But in DH, it isn't simply statistics. There is also material in the judgment which refers in the summary of the facts. So paragraph 27, which is at page 1194, to recommendations, and I've set this out in the respondent's case at paragraph 44b, it's page 156. So there were recommendations from psychological assessment centres which were based on grounds such as an insufficient command of the Czech language, an over-tolerant attitude on the part of the parents, or an ill-adapted social environment. So it wasn't simply statistics that showed a very considerable proportion of Roma children being sent to special schools. There were also criteria which could be seen to put Roma children at a particular disadvantage in relation to the tests that were being applied in some places in order to decide whether they should go to the special school or not. And in its judgment in DH, the court referred to the principles which it had earlier summarised. So at paragraph 184 of the DH judgment, which is page 1246, the court refers back. In fact, the footnote says paragraph 50, but that's a mistake. It's actually paragraph 60. So that's footnote 78 on page 1246. In paragraph 184, the court says, the court has already accepted in previous cases that a difference in treatment may take the form of disproportionately prejudicial effects of a general policy or measure which, though couched in neutral terms, discriminates against a group. And then it refers to EU directives and the definition provided in material which comes from the European Commission Against Racism and Intolerance. That's the incorrect footnote. It should be to paragraph 60 above. And it says such a situation may amount to indirect discrimination. And it notes that doesn't necessarily require a discriminatory intent, because that was one of the arguments that was put forward in DH. And if one turns back to paragraph 60, which is on page 1207, that is the ECRI recommendation, which includes definitions which the court sets out there. And so one sees that when the court is considering indirect racial discrimination, it has in mind this definition. This definition itself isn't expressly adopted in the Strasbourg case law, but the court plainly has it in mind because it refers back to it, and it says, this shall mean cases where an apparently neutral factor, such as a provision, criterion, or practice, cannot be as easily complied with or disadvantages persons belonging to a group designated by a ground such as, the first one there is race, unless this factor has an objective and reasonable justification.
Well, that almost entirely does mirror the EU definition, except that it leaves out the crucial point that the provision, criterion, and practice, which has this, puts a group at a particular disadvantage, must also put the particular individual at a disadvantage.
My lady, it does leave that out.
Yeah,
Yes.
but it's rather important that one brings that back in, because there could be other reasons for the disadvantage suffered, other than the systemic discrimination.
My lady, there could be other reasons, but my submission...
Well, in other words, they may be guilty, or they may actually require to be in a special school. So you can only complain about the systemic disadvantage if you have suffered from the systemic disadvantage for no good reason.
My lady, one might think that until one turns to paragraph 209 of the judgment in DH, where one sees that, in fact, the European Court of Human Rights awarded a remedy to the applicants as members of the community, saying that they necessarily suffered the same discriminatory treatment and that it didn't need to examine their individual cases. And in terms of the, if I could just deal with this point while I'm on the DH case, because it's convenient to do so. In terms of the degree of the degree of disproportion which was shown by the statistics in the DH case, one can see there are some statistics summarised at paragraph 190 on page 1247. I won't read those out, but these are taken from a more detailed description earlier in the judgment at paragraph 18, page 1191, where somebody has done a calculation which says that those statistics show that Roma children were 27 times more likely to be placed in special schools than non-Roma children. And also at paragraph 18, there's a reference to data and estimates that show that in the Czech Republic as a whole, not necessarily the region where the applicants went to school, between 50 and 70% of Roma children were in special schools. And in Ostrava, where the Roma children did go to school, the percentage was 56%. And then that's the figure that we see in paragraph 190 compared to only 1.8% of non-Roma children. And these figures are summarised in paragraph 193 on page 1248 by the court as showing that their number, so the number of Roma children in special schools, was disproportionately high. So when the court in Strasbourg is talking about a disproportionate number, in my submission, it is talking about really quite extreme figures. It's not simply saying there is a difference, a statistical difference between two groups. And my submission on the evidence, just trespassing on that subject for a moment, is that the evidence simply shows that there is a disproportion and nothing more. And finally, this point comes back, I think, to my Lady Hale's point about whether the court in Strasbourg distinguishes in quite the same way between indirect and direct discrimination as is required under EU law. At paragraph 42 of the judgment, there's a reference to some evidence which suggested, that's page 1197, I don't know whether I gave the reference, if the court would like to turn it up. And one sees there a reference to an ECRI report on the Czech Republic, which noted that channeling of Roma children to special schools was reported to be quasi-automatic. and one sees there other reasons why that might have been the result of the tests. So the children are being asked to undergo tests alongside non-Roma children who have attended kindergarten in circumstances where the Roma children haven't attended kindergarten. And in those circumstances, it is unsurprising that an apparently neutral measure of requiring the children to undergo a test significantly disadvantages the Roma children, who are much less equipped to pass the test. And one can't draw from that any inference about whether they have a mental impairment and should therefore be at a special school. So that's the issue that was being dealt with in the DH case and how the court dealt with it. And in a subsequent case, which I mentioned earlier, Ursus and Croatia, another case about Roma children being wrongly placed in special schools, and this is tab 19 of the authorities volume. There was an apparently neutral measure, but the difference in that case was that it was applied only to Roma children and not applied to non-Roma children.
Do you want us to look at that case?
I would, my lady, like the court to look at paragraphs 152, which is page 1314, and the following paragraph, 153. And at paragraph 152, the court refers back to the statistics in the DH case and also the Sampanis and Greece case, and compares, at the top of page 1315, the court compares the statistics in those two cases with the statistics in the present case. And notwithstanding the fact that the statistics showed that in one of the schools attended by the applicants in Ursus, a majority of Roma pupils attended a Roma-only class. While they say in the other school the percentage was below 50%. Well, that obviously could mean many things, but the impression given is that it was perhaps not much below 50%. They contrast that with the statistics in the other cases, and they say in the last 4 lines of paragraph 152 that this confirms that it was not a general policy to automatically place Roma pupils in separate classes in both schools at issue. Therefore, the statistics submitted do not suffice to establish that there is prima facie evidence that the effect of a measure or practice was discriminatory. Now, we would recognise that as a situation of direct discrimination rather than indirect, I think, if the policy was so extreme as to automatically place Roma children into a class, into a separate class. But the important point for this case is that even statistics that showed really quite a disproportion between two groups of children were not sufficient to show indirect discrimination on this line of case law, because they didn't establish a general policy of placing the Roma children in separate classes. And then the court goes on to consider...
That was one of my reasons for saying it's very hard to work out what Strasbourg is doing in relation to direct and indirect discrimination. Because if there's a policy directed at a particular racial group of treating them less favourably, we'll assume the separate classes are less favourable treatment, because they usually are, that's direct discrimination. It's not indirect discrimination.
My lady, I think it probably is direct discrimination, but that does raise the very interesting conceptual question of whether targeted, deliberate, indirect discrimination is actually direct discrimination. But I don't think that's an issue that we need to...
It's difficult to see how it could be other than direct discrimination if it's targeted, isn't it?
But my lord, I certainly would agree with that, were it not for the fact that the legislation, the EU legislation, draws such a clear distinction. Something is either direct or it's indirect, and that could be described in ways that qualify it as indirect discrimination. So, as I say, it's a conceptual issue that I don't think we need to trouble ourselves with.
But Ms. Banfield, when we go on to paragraph 155 on page 1315 and read the court saying that in the circumstances, even without any discriminatory intent, the fact that the measure was applied exclusively to the members of a singular ethnic group calls for an answer. Mr. Anderson says, well, apply that reasoning to the situation here. You've got the January to June report that there was a surprising over prosecution of BME barristers. It calls for an answer. So what do you say about that?
My lord, what I say about that is that there is the case put by the claimant is that there is a disproportion in the numbers. She does not say that, she doesn't explain anything underpinning the disproportion in the figures. She simply says, look at the figures. And my submission is, on the basis of DOC, merely saying there is a disproportion in the figures is not enough. And there is no evidence that only BME barristers were prosecuted, for example, or that they were only BME barristers were prosecuted in a particular way.
I think she says, look at my case. Look at the way in which proceedings were taken against me on a wholly spurious basis. Now, what was going on here? And then she reaches for the January to June report and says, well, what about this? Over to you, Ms. Padfield.
My lord, to that I say two things. One is that if one is looking at the ingredients of indirect discrimination under DH, one is not looking at the features of the individual cases of the applicants. The court just doesn't look at that.
But they didn't in that case, but that doesn't mean to say that they wouldn't in another case where it was appropriate to do so.
Well, my lord, this is the case law on which the claimant relies for her claim. And the other answer that I would give to that point is that the January to June 2013 report itself provides an explanation, which is that the process, having examined all the case files and conducted interviews with people and gone through the process in a considerable amount of detail, the conclusion is that the process itself is not discriminatory. And so the explanation for the figures lies outside the processes of the respondent.
We're not trying this case. We're simply deciding whether it was brought out of time. And we may or may not entertain your application, which is to say that Mr. Justice Warby was wrong to let part of the claim go forward. That's what we're doing. We're not trying the case. And we're certainly not going to decide these mega questions of the meaning of discrimination in Strasbourg case law in an application such as this, in a proceeding such as this.
Lady, I accept that, of course, but in order to decide whether the act complained of is a one-off act with potentially continuing consequences, which is the respondent's case, or a continuing act, one has to identify what the unlawful act is. What is the nature of the unlawful act of which the claimant complains?
Yes, I realise that's your argument. I'm just thinking that we're spending too much time on the substance of the claim as opposed to how you would draw the distinction between a one-off act with continuing consequences and a process or state of affairs.
I'm grateful, my lady. The claimant's claim is, as set out in its case at paragraph 8, that the respondent shouldn't have prosecuted her. That's page 127, and should have brought the prosecution to an end, and that the respondent failed in its duty with every day that it was allowed to continue. The act complained of is, as I have just outlined, indirect discrimination in that disproportionate numbers of BME barristers were prosecuted. And on the claimant's case, all BME barristers who were prosecuted would have a cause of action. Now, the claimant points to particular features of her case and says, well, I shouldn't have been prosecuted because, well, you can see these things happened in my case. And as the court knows, I rely on the decision of Mr. Justice Field saying there was a case fit to go to the tribunal, and on the decision of the disciplinary tribunal as factual reasons why, if you were saying, well, some BME barristers shouldn't have been prosecuted, the claimant can't bring herself within that class. But my more fundamental point is that in order for the claimant to have a claim under Article 14 for indirect discrimination, she doesn't have to show any of those factors. She doesn't have to show that she shouldn't have been prosecuted. It's enough that she can show that she was a member of the class. So if Mr. Justice Warby is right, that's all she needs to show, that she's a BME barrister who was prosecuted.
And then you would say, well, yes, but that wasn't there was no causal connection between her being a BME barrister and the fact that she was prosecuted.
What I would say is that's a one-off act of discrimination, and if one tests it by saying, well, if another BME barrister who couldn't point to particular features of their prosecution were to say, you need to stop this prosecution of me, it's unlawful because it's discriminatory, that's what DH says on the basis of Mr. Justice Warby's finding, my core submission is that is not correct. A BME barrister could not have applied to have a prosecution stopped on the basis that it's discriminatory, based on DH. And if that is correct, then the continuation of the prosecution or the failure to bring the prosecution to an end was not an unlawful act within Section 6.1 of the Human Rights Act. So there's an unlawful act at the beginning, but there isn't a continuing unlawful act, because if there were, any BME barrister would be entitled to say to the Bar Standards Board as a public body, you are acting unlawfully in continuing this prosecution against me, and you must therefore bring it to an end. And similarly, the fact that there's a disproportion in the numbers doesn't actually show that there were any BME barristers who should not have been prosecuted. It simply doesn't demonstrate that. It may be that actually all of the BME barristers who were prosecuted should have been prosecuted, but in addition, more white barristers against whom complaints were made by third parties should also have been prosecuted.
You're saying Mrs. O'Connor should have been prosecuted?
My Lord, what I'm saying is that her cause of action doesn't require the court to consider whether or not she should have been prosecuted. The cause of action based on DH is, if Mr. Justice Warby is right, is a cause of action available to any BME barrister who was prosecuted in the period covered by the statistics.
I think this ties in with what my Lord Lloyd Jones was inviting you to do. This was to deal with what Lord Justice Elias said. Lord Justice Elias clearly took this claim as being one relating to Mrs. O'Connor herself and the way her case proceeded. And he contrasted that, which he said was the principal way in which the case was put, with the the broad systemic sort of case and said, well, different considerations might apply, but that's not what's being said here. But you're saying it is what's being said here.
My Lord, what I'm saying is that that is the cause of action on which the claimant relies. That is the DH cause of action. And in the notice of appeal, Mr. Southey says it's not correct that any barrister, any BME barrister could have brought a claim. It has to be someone who had proceedings brought against them. And he also says it's the bringing of the proceedings which is the relevant act in terms of the running of time. He says the fact that there may be a disproportionate number running over a longer period is not correct. So he says he disagrees with what Lord Justice Elias says to that extent. But if one looks at DH, it is the case that the court didn't say it was necessary to look at what happened to the individual students. It doesn't say, well, should you have been placed in a special school? Well, what happened as a result of you being placed in a special school? It simply says, you have all brought this claim, and we can see how Roma children were being treated, and therefore you have a claim, and they are all awarded €4,000 in terms of damages. It's actually considerably less than they asked for, but they are all awarded a sum in damages.
Ms. Padfield, is this not a case in which the central allegation is the discriminatory treatment of the claimant herself? I can see that DH is prayed in aid because the disproportionate treatment of BME barristers is then said to be potentially evidence of discrimination against the claimant herself. But that's different, isn't it, from a situation in which the challenge is to the state of affairs which exists?
My Lord, the claimant brings the claim on the basis that she should not have been prosecuted. That is her complaint. But the claim based on DH doesn't actually give rise to the consequence that she says flows from it.
I'm sorry, I didn't catch that last.
The claim based on DH doesn't give rise to the consequence that the claimant says flows from it.
But is my Lord not correct in saying that certainly, so far as Lord Justice Elias is concerned, he considered that there were two stages. First of all, whether or not there was discrimination against this individual claimant, and on the basis that the charges against her were found to be baseless, that provided prima facie evidence to that effect. And then one moves to the question, what's the explanation for that? And it's at that stage that recourse to the statistics becomes relevant. That seems to be the purport of paragraph 38 of his judgment, does it not? Page 178.
My Lord, essentially we say that is not a legitimate way of bringing the claim based on DH.
So you would disagree with its characterisation by Lord Justice Elias?
I would disagree with it to the extent that it permits the claimant to rely on the statistical evidence of indirect discrimination and then say, and now you can look at all sorts of features of the prosecution of me, which the court in DH didn't look at all. It didn't look at the individual cases of the claimants in that case. to the extent that she says, well, you can add together the DH cause of action and my complaints about the way I was treated in my prosecution in order to make a claim which is open to me, which I say is continuing because it means that the prosecution of me should have been stopped, even though she accepts, as she must, that it can't be the case that all BME barristers who are prosecuted should not have been. It can't be the case that all prosecutions of BME barristers were unlawful. So to the extent that Lord Justice Elias's judgment legitimises the mixing together of those different elements based on DH, then yes, I say it's wrong.
But in a case such as the present, what happened to Miss O'Connor in the proceedings might be said to require some explanation. Why is the disproportionate treatment of BME barristers not potentially evidence in that regard? Which is what Lord Justice Elias is saying as I read it.
Well, my lord, that perhaps brings me onto the subject of the respondent's notice in terms of whether this actually is a DH case at all or not. But even leaving that aside, the claimant obviously has to, if she is to claim damages, which is what she is claiming, for breach of Article 14, she has no option but to pray and aid what actually happened to her. And for the reasons that I've given, that isn't something that the court in DH said was necessary.
Well, they said it wasn't necessary, but that doesn't mean to say that it can't be done. The fact that they went another leap and said, we're not going to investigate the situation of these individual children because we think the picture is so bad that they must have suffered unjustly from it. They only gave them €4,000 apiece compensation, which is much less than they were claiming. And what they didn't do was the tortious thing and look at what the effect on their education would have been had they not been placed in special schools. So the remedy is quite important. It doesn't mean to say that they wouldn't have looked at the individual circumstances if they felt it would be useful and necessary to do so.
But it demonstrates in my submission that it's not necessary for the cause of action in DH.
Well, it wasn't in DH. It might be necessary in this one.
But it is DH on which the claimant relies in order to bring her claim, and it's DH on the basis of which Mr. Justice Warby held there was one surviving adequately pleaded and evidenced claim of discrimination. So that is the foundation of the claimant's case.
Is that paragraph 62 of his judgment that you're referring to, where he talks about DH? Where he looks at it in two different ways, because one way in which DH is relevant is to show that statistics of showing disproportion can be evidence. And that's what he's talking about in the second part of 62, before he goes on to say what he finds to be sufficiently pleaded in this case.
My lady, yes, forgive
That's
me.
the paragraph that you're in some way you are tying DH in with Mr. Justice Warby's determination of what is the surviving claim in this case, the properly pleaded claim.
Yes, that derives initially from paragraph 54 on page 195, in which Mr. Justice Warby summarises the way that Mr. Southey presents the case for the claimant.
But then he, in 63, boils it right down and says what he says is sufficiently pleaded. And we don't get very much more from the pleadings themselves on this. And it's that she's been discriminated by the bringing of the disciplinary proceedings against her, which in 79, he deals with potentially up to the point of the end of the tribunal's proceedings, not just the actual launching of the proceedings, but the end of the tribunal's decision. But for some reason, he doesn't even consider the appeal, does he, in this decision?
The reason that he doesn't consider the appeal is because there's no evidence of disproportionate numbers in relation to any opposition to
That's
an appeal.
not an answer, is it? Because if the process of prosecution doesn't end until the end of the appeal, he needed to consider that. Putting it loosely, the prejudice to her doesn't stop until the end of the appeal.
My lady, that's correct. And he found that the claimant continued to be a victim even after the decision of the visitors on the appeal. My lady, in terms of the question considered by the Court of Appeal as to whether the disciplinary proceedings are a single act or a series of acts, about that I would simply say I've dealt with that in the respondent's case at paragraph 24, and I would simply say that issue is in my submission different according to whether one is looking at Article 6 on its own or discrimination in relation to Article 6. And in the present case, we say that the act complained of, contrary to Article 14, in terms of making the decision to refer the claimant to a disciplinary tribunal, is a distinct act.
That's what you say.
That's my submission. And that the fact that if one were looking simply at a claim based on Article 6, one would, as the court in Strasbourg would, want to look at the whole of the proceedings, inevitably to see whether there had been a fair trial. One can't determine that, we accept, of course, until the outcome of the proceedings as a whole. We say if one is looking at indirect discrimination based on DH, that question is different. One is simply looking at the disproportionate number. So one might term it as the greater risk, perhaps, that a barrister would be referred to a disciplinary tribunal, or a greater risk compared to a white barrister. And as I've said, it doesn't mean that actually there was any BME barrister who shouldn't have been prosecuted. That doesn't result from the evidence in the report before the court. Coming on, if I may.
Well, I'm looking at the time.
I was just looking at that, my lady.
You did look as if you were grinding to a bit of a halt, but what have you got left to deal with?
My lady, I have to deal with the question of whether opposing the appeal is a separate act.
Yes, you do. Well, would you like to turn to that after the short adjournment?
If that would be convenient.
Yes, it would. So we'll look forward to hearing from you again at 2:00. The court is now adjourned.